So you've poured your heart and soul into creating a unique brand or a killer product design here in India. That's amazing. But what's stopping someone from just coming along and ripping it off? Well, today we're going to break down the two key legal shields you have in your corner: trademarks and designs. Let's get right into it.
First things first, let's get the big picture straight. A trademark is all about your brand's identity. It's that unique signature, a name, a logo, maybe even a sound that screams, "This is us." A design, on the other hand, is purely about how the product looks. We're talking its shape, its pattern, its color combo. It's the product's visual personality.
So here's our game plan. We're going to start with what you can actually protect. Then we'll meet the official IP gatekeepers in India. After that, we'll get into the nitty-gritty of making it official. We'll also cover what to do when those pesky copycats show up. And finally, we'll wrap it all up with the key things you need to remember.
All right, let's kick things off with the first big question. What exactly can you protect? This is all about getting the fundamentals of trademarks and designs down cold.
Under India's Trademarks Act, the definition of a trademark is actually super broad. The main thing is that it has to be something you can put down on paper or on a screen to show how your stuff is different from the next person's. And this isn't just about logos and names. It can be the unique shape of your box, your packaging, or even a catchy jingle.
Now, a design is a whole different animal. The law here is all about visual appeal. It's about the features that are judged, and I quote, solely by the eye. So we're talking about the pretty stuff, the ornamental bits, like a cool shape or unique pattern. The key thing to remember is that how it works doesn't matter for a design registration. It's all about how it looks.
And here's a really fascinating legal quirk for you. A trademark isn't like a piece of land that you own, period. It's what lawyers call a use right, and it's completely tied to your business's reputation and goodwill. What does that mean? Well, you can't just sell your trademark by itself. Its value is totally wrapped up in the reputation of your company.
Okay, next up, the IP gatekeepers. Let's meet the official bodies in India that are in charge of this whole system.
So yeah, who is running the show?
In India, there are a few key players you should know. The big one is the Controller General of Patents, Designs, and Trademarks. That's a mouthful, so people just say CGPDTM. For what we're talking about, the division you'll deal with is the Trade Marks Registry, or TMR. And it's also good to know that things got a bit simpler back in 2021. So now if you need to appeal a decision, it goes straight to the high courts.
Now for the really practical stuff. How do you actually make your trademark or your design official? Let's take a walk through the registration journey.
Okay, getting a trademark has 5 key steps. First, you file the application. Simple enough. Then, an examiner at the registry looks it over to make sure it's distinctive and not stepping on anyone else's toes. If it gets the green light, it's published in the Trademarks Journal. This starts a 4-month clock where anyone from the public can object. If nobody opposes it or if you win any challenges, boom, you get your registration certificate and all the exclusive rights that come with it.
Just a little heads up here, you've got to be prepared to wait. Even if everything goes smoothly with no objections or oppositions, you're still looking at about 18 to 24 months from start to finish. So yeah, patience is definitely a virtue here.
For designs, the timeline's a bit different. Once you register your design, you're protected for an initial 10 years. After that, you can renew it just one more time for another 5 years. So all in all, you get a maximum of 15 years of protection.
And this brings us to the whole reason we register in the first place, dealing with copycats. Let's dive into what you can actually do when someone starts imitating your work and how you can fight back.
When it comes to designs, the legal term you need to know is piracy. The law is pretty clear. It's piracy when someone uses your registered design or a fraudulent or obvious imitation of it on a product they're selling, all without your permission.
This quote from a famous case absolutely nails the legal test for design piracy. The court isn't just looking for a perfect photocopy. The real question is this: did the other guy lift the essential part of your design? The very thing that makes your design special and new. That's what they're looking for.
Let's look at a real-world example, the battle of the water bottles. Cello versus Modware. Cello argued that Modware's Kudos bottle was a direct copy of their Puro bottle. The court looked at Cello's unique features, that specific curve, the 2-part cap, the color scheme, and basically said, yep, we agree. They found Modware's bottle was so similar that an average person would get confused, and Cello won.
Now, let's talk about taking legal action for trademarks. You've got 2 main weapons. The first is infringement, and that's for registered trademarks. Think of it like someone trespassing on your land when you have the official deed. It's a much clearer case. The second is passing off, and that's for unregistered marks. Here, you have to prove that someone's trying to fool customers into thinking their product is yours and that this is hurting your business. It's a much tougher battle to win, which is exactly why getting registered is so critical.
All right, let's bring it all home with our final section, protecting your property. These are the absolute must-knows for every single creator out there.
Before you even start an application for a design, hold on. You need to make sure it's actually eligible. The law says you can't register a design if it's not new or original, if it's already been shown to the public anywhere, if it's just a tiny tweak on an old design, or if it contains anything scandalous.
So here's a quick snapshot of the life of your IP. The moment you file for a trademark, you can start using that little TM symbol. Once it's officially registered, you graduate to the big leagues, the R symbol. Remember, trademarks can be renewed every 10 years, basically forever. Designs, though, get 10 years of protection plus 1 5-year renewal. After 15 years, that's it. And if you do end up in court fighting for your registered rights, you have some really powerful tools. You can get an injunction, which is a court order that forces the copycat to stop, like right now. You can sue for damages to get paid back for your losses. And you can even demand an account of profits, which means the infringer has to give you all the money they made by stealing your idea. Look, at the end of the day, your creative work has real, tangible value. Your brand, your designs, that's your unique signature on the world. So the final question is pretty simple. Isn't it time you protected it?